You're welcome back. Thank you very much for being part of this show. And then, okay, is this for my purpose of reading or what? This, Dr. Parko Sindum, I suppose, saying that, so how can you discuss the PPP suit against government of FQ and not invite anyone from the PPP to present its case? Oh, has your case been badly presented, Doc? Forgive us if that's your feeling. It says, is the embargo against PPP during the 2012 election? Okay, I'm sure there's no embargo. And I've had the opportunity to tell some of the PPP people that a posture that suggests that the media is against them doesn't help them, because I think that they have gotten sufficient media, coverage. Yeah. And I am clearly aware of efforts by the production to get Dr. Indum or his people on this matter. Thank you very much. Sorry about that anyway. Now, let's talk about Balkan Energy and the award of $12 million in their favor in respect of the matter that we know about now. The case was filed against the Republic of Ghana, that is government, in the Permanent Court of the Arbitration in The Hague, and that was in 23rd of December 2009, and lasted for all the periods at a point. And then we have the Supreme Court also coming in subsequently on the back, before even the Amiduk strain of cases, which were very emphatic on the fact that parliamentary approval was non-negotiable. We are aware of the suit in respect of the same case, in which the court suggested that the parliamentary approval was very, very critical. Now, not to bore you, the point now is that questions that is being asked. I've heard Mr. Aiko to speak about the issue and suggest to the effect that Balkan Energy is deserving of what has been awarded them, but also say that this can also be sort of renegotiated somehow. Can you help us to appreciate your position on the development?
Well, thank you. I think the issues are very clear in this matter. The Constitution really provides that you need to put international agreements before Parliament for approval.
Article 181.
181 and 5.
Right.
Others dealing with of some international, commercial transactions may also be sent there. Now, according to the Supreme Court ruling, because it was not late, therefore it is null and void. Now, you are dealing with foreigners. My position has always been that the whole idea of international arbitrations is that you may not, get justice in a country where you claim there has been some breaches of some agreement. And therefore, it will worth your while to rather look outside. And most investment agreements, you find these arbitration clauses somewhere embedded that, look, in case of a conflict or misunderstanding, we may choose to go for arbitration elsewhere. So these things are done. I mean, Ghana, having signed that agreement, you are bound by it. And I believe, if you went to court straight, people sometimes raise the issue that, well, a precondition for coming to court is that you should have gone to arbitration. So why don't you stay proceedings, go and do your arbitration, and then come back? Of course, it is for the court to decide whether going to arbitration would worth the while of everybody before then. Now, this is a foreign transaction, if you like, international commercial transaction. They are not Ghanaians. They are dealing with your government. If you know that your constitution says you should go lay this thing before Parliament, it is your responsibility to do that. I do not think that it is a responsibility of the other side to insist or to find out what your laws are to ensure that A, B, C, D ought to be done. And we have had this kind of situation before, not in an international, but a very local, circumstances where an individual who was given an assignment knew that he ought to apply for consent to assign. He failed to apply for the consent to assign. Then he tried to wriggle himself out of the transaction, saying that, but I have not given you any consent to assign. So your agreement itself is void. And that is what government of Ghana appears to be doing. That, well, we've entered into the agreement, come and do the refurbishment, do ABCD for us. The people have done their work. Somewhere along the line, you have some difficulty with them. Then you rush to your Supreme Court. Your Supreme Court says, oh, it was not late, and therefore it is not valid. They chose the other alternative of going for international arbitration. I have not seen the power purchase agreement, but I presume that it should be there, the right to go to international arbitration. And there they've been giving an award on the basis of quantum merits. For work so far done on the badge, please pay them 12 million.
There's no difference when you say quantum merit and they speak about restitution.
Well, not much. My beef is this, where government spokespersons are saying that, oh, they are in fact entitled to it. If you know they are entitled to it, then why all this, noise about the fact that you're not going to pay them until they had to go, if you knew they were entitled to it? In any case, the other reliefs that they sought were not granted.
Yeah.
But what is the effect of a court saying pay somebody? Exactly what it means exactly is that you become a judgment debtor. We are saying that it is not a judgment. So what is it? Go and pay the person some amount, and you know that it can't be executed. You know that it can be executed. Your properties can be seized, including the badge itself can be a subject matter of execution for them to get back their 12 million cedis.
As far as you are concerned, they were asking for 40 million.
Yes,
and they've been giving reliefs. Yeah, and some other reliefs, and they've been giving 12 million. And you think that's okay? We should just shut up and pay?
So long as they have worked, and I believe that those who heard the case felt that they were entitled to work so far done on that machine. I mean, why do you take the benefits of the work they have done and yet avoid the contracts? That's what you are doing. Is it not an unjust enrichment kind of situation? I've taken money, I've refurbished your badge for you. You are saying, I didn't get a parliamentary approval. I failed to do that, and therefore it's null and void. As a result of that, I'm not going to pay. What the people are saying that, assuming that were even true, pay them. And this is not the first time the Supreme Court itself has done this sort of thing. They have applied it, I think, country waste. This country waste thing came,
waste, AG versus Faro Atlantic,
and all those things
before they came to Balkan Energy, and then the other Amidu cases.
Exactly. That assuming that the agreement itself is void or voidable, because we are going to take some advantage under that sort of agreement, please pay for the work so far done. And so be it. If Diana and his people have gone around collecting, garbage for you, you turn around to say that agreement is voidable. So what happens to the garbage that they have collected? That is the country waste one.
What are the implications for our Supreme Court and our sovereignty? The Supreme Court takes the view that this is a constitutional matter. You would find also that the arbitral tribunal admits that, certainly there's some, constitutional thing about it, and it says that it does not want to get into all of that. Our court says it's a constitutional matter, and it says for as long as it was not put before Parliament for the prior approval, it is void.
Yes.
You don't deserve any payment. Even though Dateba subsequently makes the provision for what he says as sparring, uses the word sparingly, what Isankuma describes as the almost impassable window for restitution. What does he say? The court says this, then the Hague Arbitral Tribunal says no.
Yes, I think that...
Does it not spite our court?
Oh, that is the impression that somebody will get. But as far as I'm concerned, I believe that if you look at the PPA, there must be something there on international arbitration, that where they have a difficulty, they have to go somewhere. We have signed that agreement. We are bound by it. Didn't we know about our constitutional provisions before we went to sign that one? So we are bound by that one. And didn't we submit ourselves to the international arbitration at the Hague? We went there. We put up a defense.
You put a counterclaim.
Yes, and even a counterclaim. So what rights do you think you have? Having to
and we also got something really out of that.
Exactly.
We got a 300, right?
300,000. So I don't think that we should worry our heads over the constitutional provisions. We shouldn't. Once we are dealing with foreigners, what we ought to know is that the right for them to seek international arbitration when they have a problem with our government is almost guaranteed to anybody. There's no way he may get everything within the context in which he finds himself in your country. In fact, it is part of our investment laws, unless it has changed. But it's always been there that you can always import these international agreements into your investment, contract with the government, so that in case of difficulty, you can always go outside. It is true that, yes, it appears that they've gone against our constitution, but what they are saying is equitable. You've given me a job to do. I have done that job for you. Pay me the cost of what I've done so far. If there are any other problems and for which reason you think you ought not to pay me, I agree. But at least the order is that pay for the work I have done before you take the advantage.
I'll come to the man in charge of PPPs. Abraham, you have also been, I see you scanning through some sort of, the summation of the points as far as the award is concerned. What's your position?
First and foremost, I think this ruling by the tribunal undermines our Supreme Court. And the tribunal itself indicated that and sought to whitewash it. It says that the tribunal, while expressing its respect for the Ghanaian judicial process and acknowledging that it was not its place to decide an issue of constitutional interpretation in Ghana, where the highest court of the country, the Supreme Court, had considered the matter, it was of the view that the PPA was valid. So it's like giving somebody the right hand and taking it away with the left hand. That's what they did here. Acknowledging the authority of our Supreme Court, but yet came out with a decision that undermines.
And Supreme Court says it's not valid. They say it's valid.
It's valid, yes. So for me, this clearly undermines the authority of our Supreme Court. But I don't know how.
Are we talking about the same forum?
No, we are talking about different forums, and then for that matter,
so take
you
that
will know that there is one which is seeking to undermine the other. But for me, what I see is that...
But you see, when you stop there, for the benefit of those who are listening and watching us, the last paragraph says that the tribunal found that in the particular circumstances of this case, Balkan had reasonable expectation that government had accepted the validity of the PPA and was therefore entitled to rely on the PPA and to expect that government would therefore fulfill the obligations that it had assumed thereunder.
I also think that there is an obligation imposed on investors who come to this country to find out what laws are available in the sector that they want to invest.
You are the custodian of the law.
Yes.
You bring me a contract.
Yes.
I sign it. And you agree. So I go, I start my work. I deploy my machinery and labor. And then at a point in time, you come back to tell me, I'm sorry, I didn't get approval. So please stop work. I stop work and you say you won't pay me for the work done.
So far,
is this fair? That's the question.
As a prudent investor, you are under an obligation to know that, and that's constructive notice on you, that you don't just go into a country and start investing, that there are laws governing such investment. This is basic as an investor.
You are dealing with a government,
no,
with a state institution.
Look, I have had investors coming to me.
Ministry of Justice and Attorney General.
Senior, let me tell you something. I have had investors come that they want to know about our laws regarding the free zones. That is a prudent investor. You get the point. So I agree that you cannot, enjoy the fruit of the labor of somebody without paying that person. But it is also incumbent upon you, the investor, to do the due diligence.
I was deliberate in using the word, when you are dealing with the custodian of the law, you should still go and find out if that custodian of the law has fulfilled the law.
Government of Ghana.
The custodian of the law is not as if to say that the laws are hidden. In fact, the laws are public documents. And so if you as a prudent purchaser, you come into a country and you don't find out laws that regulate the sector that you want to invest in, then you must also take the blame. So I think that in this regard, you can have a portion of blame on both sides. So, but you see, with this ruling, I think that government will now begin to...
No, but let's be fair to the facts as far as the requirement to go to Parliament for approval was concerned. Are we not aware also, per reading through the decisions of the court so far and all the matters that came forward, have you not come across the fact that the Attorney General wrote not once but twice to say that parliamentary approval was not required?
In this Balkan matter?
That's what we are discussing.
Those facts are not available to me.
Okay.
And I can't speak to them.
I see. Proceed. You are making a
point.
Yes,
so my point is that with such rulings coming, and I agree with Ayiko too when he said that in all international agreements, there is a provision for arbitration, and most of the time it is an outside law. It's not a law that is applicable to where you are investing. So because of that clause, I think that we should begin to be careful in terms of how we enter these international agreements, because then these things will happen. And I'm afraid that this may open the Pandora's box for similar cases that went to our Supreme Court and were given this kind of pronouncement.
Right.
And so we've not seen the back of this yet, and I'm sure more of this will come up.
I see. I know someone who was very prophetic when this matter came up from the ones involving isophoton and Waterville and so on. And he made that prophecy that let the Ghanaian courts decide what they may or say what they want. International judicial arbitral bodies will demand something else. Here we are. They are demanding something else. Kweku, I know you and your newspaper has had a little bit of a banter as far as whether or not this ought to be described as a judgment debt or not. Let's deal with the substance, not the form. And there are those who say, look, ought we not also be looking at what government, in respect of the Attorney General, the effort they put in? They stepped into the case, the Attorney General and her team. They got external solicitors to work together with another one here in our country. And by virtue of that, it just may be that would have been talking about paying the 40 million they are asking for rather than the 12 million.
Yes, I will deal with that. But I plead that you allow me to deal with the form in a very, very brief manner.
Okay, go on.
And you see, when Mr. Ayikutu was speaking, I was quite excited when he came to the question about whether it is a judgment debt or it's not a judgment debt. He's a lawyer. I'm not one. And he's a very experienced lawyer, former Attorney General. And so I nodded in approval because I thought I had been vindicated to that extent. Otherwise, it's this thing, in the Hansard, 1960, my old man said something which I saw, I realized that J.H. Mason also said in 2000 and something, said terminological inexactitude. Maybe that's what I was being accused of. I'm not a lawyer. My paper doesn't have any serious legal brain there. So we put this thing out.
We stand by to assist you.
It looks as if we are being invited into the realm of legalistic,
very competent lawyers.
needless legalistic semantics. Otherwise, what was the big deal? So I just want to make that clear. We didn't go out there to create any mischief. It appears some people have developed an allergy for the word judgment debt, and that's their own problem.
It's a negative twist it has received.
So arbitral award. That's what you want.
Everywhere you are going to pay.
That's what you want. You can have it. I apologize for saying it was a judgment debt. So you want arbitral award, but you are going to pay. And if you don't pay, they will enforce it in the court of law. So bottom line, whether Jonah swallowed the whale or the whale swallowed Jonah, there was a swallow. And yet this has become an issue. I was so surprised.
All over the country.
When the substance is there. You know, and the point Amelba was making, I'm just a researcher in these things. The country waste case, the city and country waste case, was similar. The Supreme Court declared the contract invalid, illegal, but said that because some work had been done, and in doing so, let me read this portion. It says the long-standing approach in the English common law was that where a contract was found to be illegal, as in the instant case, the benefits conferred under it, namely recovery of money paid or property transferred, were not recoverable. The traditional common law approach was subject to two main exceptions. First, where the parties were not in pari delicto, I don't understand, have I pronounced it well? Or equally at fault. And second, where a party to an executory contract repented before performance. On the facts of the instant case, it was the in pari delicto exception, which was germane, and also the benefit to be recovered from the defendant statutory body was not money paid or transferred, property transferred, but rather the value of the services rendered. What the court was suggesting was that the city and country waste could not have known that the assembly had put all those things before the district tender board and all the rest to go. It was not their business to know everything. And in view of that, they were not equally at fault. You know, so the point he was making, I didn't really know
what Amaliba was talking about.
Yes, I really didn't get it.
No, you wouldn't understand.
And another just...
Why? You don't do that as a prudent purchaser. You have to do your background checks.
In view of the position of the law that we all know,
I say that I am wrong, the Supreme Court is also wrong.
In these circumstances,
there are Supreme Court decisions on Balkan.
Please.
And if you say I am wrong, is the Supreme Court also wrong?
The point that is
I am saying that the Supreme Court can depart from its... You are mentioning cases that the Supreme Court has departed from.
It doesn't matter.
Caveat emptor and caveat vendetta. Let the buyer beware, let the seller beware.
So where is your surprise coming from?
Where
is the surprise coming from?
Please, Amaliba,
I have taken a certain principle.
My disagreement with you is that even where the contract is found to be invalid, as for the benefits that you are going to take,
that's it, and that's what
you have to pay. That is what I'm telling you.
That is not what in this Balkan, the Supreme Court said in Balkan.
I am saying that in this particular case, country waste, we have
we are talking about two different cases. I am talking about Balkan.
But the principle.
So you see, don't sit on this platform to say that I have espoused bad law. That's the interpretation of what you are saying.
I have not said
Balkan has given me the authority that once the contract is invalid, everything else cannot start.
And I'm telling you that what the International Arbitral Court has done is nothing different from what
they
the
did
Supreme Court did in country waste.
But I am saying that there's also Balkan. There's also Matinamidu and
Thank you.
Matinamidu and what? Mention the other one.
That is what is telling you that somebody has predicted they may all come back.
I even predicted that. I said okay.
Then what is your beef?
So don't say that I espouse bad law.
Okay. Baku is doing some common law. Please, let's hear him a lot bit on that one.
You know, and I'm not sure. Fortunately, we have three of you are lawyers. I've been going through the Balkan judgment, the Supreme Court
is not available.
No, the Supreme Court one. He's referring to the
Supreme Court.
Balkan.
No, I have the one here.
No, that's
the new one. I have it here.
Okay.
The Arbitral Award even made mention of that.
It's supposed to be 100 and how many pages?
Almost 200 pages.
Right.
I got it only last night.
So read this one. You see it.
No, I got it last week.
Last
night.
Last night.
Yes.
Oh, okay.
Yes. See, I don't think the Supreme Court ruling, the May 16, 2012 on Balkan, I don't think it was very explicit that the contract was null and void. Because when I read here, I don't see that. You see, maybe it was implied. Because let me read the...
validity is different from declaring it null and void.
Interesting. That's education for me. But it says here, all these circumstances, after going through all the arguments, said all these circumstances cumulatively lead us to the conclusion that our answer to the first question referred to this court is that a power purchase agreement dated 27th July 2007 between the government of Ghana and Balkan Energy Limited constitutes an international business transaction within the meaning of Article 1815 of the Constitution.
Yeah.
Then it came to the arbitration and indicated that arbitration cannot be considered as an international transaction. But then this is the conclusion. The case is accordingly remitted to the High Court for this court's interpretation of Article 1815 of the Constitution to be applied in the proceedings before it.
Because that is
Then,
what happened. The matter was going on in the High Court.
Yes, let me finish.
There was a questioning for interpretation.
They didn't go back to the High Court.
Right.
They went to the arbitration. Both parties. They didn't go back to the High Court. What then the court said was to ask Parliament, we would like to end this opinion by repeating our request
to
Parliament to enact a bill indicating what modifications it wishes to make to Article 1815 of the Constitution. This step will bring greater certainty and clarity to the law. They all proceeded to the arbitration. They didn't go back to the High Court. At the arbitration, what happened? Ghana was, I've heard, because I've been attacked within that contest, that Ghana was prepared to pay for the work done all along. But if you read this thing here, our counterclaim, the first one was that we wanted their claim dismissed in its entirety.
Right.
And we were proceeding on the premises that the contract or the agreement was null and void, which is what we lost on. I don't know whether I'm right.
You are.
We lost on that one.
Yeah.
I am happy that bottom line, Balkans didn't get all the reliefs they were seeking. Why, as a Ghanaian, I'm happy that instead of 40 million or 3 billion, we are paying 12 million. But we should not create the impression that that 12 million was procured voluntarily. It was not. And if you read this judgment, the point about the Supreme Court and the thing, I think it's well explained. It's well explained in paragraph 388. And I would want to read it and conclude.
Okay.
It says, because of the arguments that went on in Ghana, the Supreme Court, and what happened there, the difference. This is what the panel says. At this point, and with due deference and respect, after having considered the Supreme Court's judgment in detail, the tribunal must depart from the conclusion reached by that court. The tribunal is convinced by the claimant's views on the need to apply a test taking into account the totality of the circumstances, quote unquote, as the guideline for determining whether a given agreement is subject to the constitutional provisions discussed. It is not enough to identify the foreign components of the PPA, which, as noted, do exist, but also the fact that the PPA was entered into by a Ghanaian company registered in Ghana cannot be ignored. Among other features arising from this fact, there is the evidence that the Balkan Energy Limited's principal base of business is in this country. The production envisaged at the PPA is to supply the domestic electrical market, and payments were to be made in Ghana. Thus meaning that the performance under the PPA was entirely a domestic business. Questions of taxation in Ghana have also been invoked by the claimant as evidence that the business was considered a domestic venture. Moreover, even if in international arbitration and international principles of commercial law, there is a rather liberal view to broadly consider what is to be regarded as international, this is not unlimited, as the claimant noted, citing the United Nations Convention on Contracts for the International Sale of Goods, 1980.
So it's also important to recognize that Balkan had registered or incorporated a company right here in Ghana, Balkan Energy
key.
Ghana.
That is key.
Right.
And that informed the shift or the departure, if you like, from what our Supreme Court did. All these things need, I believe that at the end of the day, the call for parliamentary modification may help. In spite of what the categorical effects of the Amidu and all those things, Parliament still must do something about it. 1815.
Thank you very much, Kuku. Now, I come to you, and I'd like to hear you briefly on that, and more importantly, why it is taking Parliament forever to do what the Constitution requires you to do in respect of Article 181.
Well, first of all, let me just take my turn on this issue. If you know the historical development that leads to, or that led to the ruling, you would understand that Balkan Energy was not completely open and committed to doing what it sought to do, and that they were not fair to the people of Ghana. They signed an agreement, a PPA agreement, in a form of a memorandum to provide service to the people of Ghana and the agreement said they should repair, rehabilitate, and operationalize and commission the Osagyewol badge. And then they signed the agreement and they started. Subsequently, outside the agreement, they were asking for the auditing of all electrical lines. They were asking for all the components of the badge, which were not within the agreement. And their attention was drawn to the fact that this is not what we asked you to do.
You state their role, their obligations under the contract.
Yes.
You don't state your obligations under the contract. Because under the same PPA, you as the government of Ghana was under obligation to provide certain things. You're supposed to, is it electricity on site?
No. You were asking for auditing all our lines.
But the tribunal ruled that we were also at fault relative to the agreement, except that I think Balkans was greater.
Exactly.
Yes. Yeah. That's number one. Number two, look at what they were demanding as judgment debts. They initially demanded $2 billion. I mean, the whole badge cost $110 million. You know, constructed in Italy and brought here. You are asked to do some work on it. That will cost about $20 million. And you are asking for damages up to the tune of $2 billion. This is dubious. and I don't think that, and I supported the Supreme Court when they started looking at the nitty-gritty of the issue. Let's go beyond the fact that there was an agreement. Let us see what entered into the agreement. Did it reflect all the tenets of a contract that has an international connotation? I've heard the argument that it doesn't, it's a domestic company and that it was wholly registered in Ghana, but wholly also owned by Balkan Energy. There was no Ghanaian ownership. So let's go beyond, let's take the veil of the fact that it's domestic, and it became international. And that is why the Supreme Court thought that there ought to have been an agreement. I mean, there ought to have been parliamentary approval to it. So, and we are also calling the 12 billion judgment debt. I do agree with Honorable Marietta Brew when she said that it's not judgment debt. The people said, look, we are losing everything, but we have spent $12 million in repairing this thing. That one, the court should give it to us. If it were judgment debt, it would have been the 40 million or the 2 billion that.
But Ghana was disputing. Ghana did not offer to give them any money. We said they didn't deserve it because the contract was invalid.
Yes.
That was our position.
Yes.
So the 12 million didn't come from you.
Yes. So
it's a determination made by the tribunal.
It's as a result of judgment.
Yeah.
But you see,
yes, thank you.
The understanding of judgment debt is our previous understanding of what happened. I'm not saying that I don't have an authority to give a definition to it, but the trends and the precedents that we saw in judgment debt was to ask for monies beyond what you have expended.
Why did we call the CP
losses.
payment judgment debt?
Oh, no.
CP.
Anytime
CP was arbitral award.
An award against
wasn't it?
You.
Yes.
Construction, that is a judgment debt.
CP. But we labeled it judgment debt.
Yes. So,
the Attorney General, the Minister of Finance, Parliament, everybody labeled the CP thing as judgment debt. Why are we running away from it today?
I think that we should go beyond the definition.
It's clear.
And then begin to examine why the judgment debts are occurring.
Yeah,
why
that's a different matter altogether.
And why in this instant, 2007, and he was to take, Balkan Energy was to take 90 days in commissioning this badge. They failed to do that. They demanded more than the PPA agreement, and they insisted on what was not in the agreement. Eventually, it had to go to court. And today, they are taking their...
When you say they fail, I remind you also that they also tell you you also did not perform your part of the duties that you were supposed to do under the contract. And you are introducing some very interesting element as to Balkan Energy Ghana, not exactly being a domestic, entity,
Yes.
so to speak. But we know that it wasn't Balkan Energy Texas. It was here in Ghana. And the Supreme Court, you are saying, didn't lift the veil, so to speak.
They did.
They did?
They did, and saw that it was owned wholly.
The Supreme Court did?
They did. And saw that it was wholly owned by Balkan Energy outside Ghana.
I see.
International, yeah.
Which, okay, you may not remember with exactitude, but which page exactly of the judgment?
I'm reading the summary of it.
You're reading the summary of it.
And then Justice Atuguba
I think there's something
realized
to that effect.
Right.
it was owned wholly by Balkan Energy.
They said things to that effect.
Okay.
Yes. So if that is the case, it couldn't just run away from the fact that it was not an international transaction. And that is the position of the Supreme Court. And I think that it was right, and we should insist on our laws,
Right.
that all transactions, people who want to do business with us also have the obligation to understand our laws and to make sure that they don't throw away money. Because if you go and somebody does 419 to you, and you say, oh, I didn't know will not solve the problem. Not knowledge about the law is not an excuse to violate it. If you do, the judgment will take its course.
Okay.
So what's the essence of having a local
lawyer to deal with matters that will come up when you are investing? What's the essence? Is that lawyer just there to be advising you on other matters, but not the law? So I think that the investor has a responsibility to mandate his lawyer to find out the laws, regulating that sector.
Kuku is still trying
Yeah,
to
it's-
look
you
for.
see, let me-
But you see, Databa was very specific. He said they refused to lift the veil. So when the discussion is going on, it should not suggest as if the court did lift the veil.
Yeah, yes, that one I agree. But the point, they went ahead to explain why they thought was international transaction. And the point that
Why
even
would
the
they have
local
declared it
company
foreign?
was owned
Right.
by
Why
a
could they
foreigner.
have
They made all those
Yeah.
points. Yeah, but I understand what you're
Okay.
saying. Yeah.
Now let me share a few of your comments here with you. This one says, while Balkan Energy was struggling to get the Osagifo badge to cough, a Reuters report captured its bosses fraudulently misrepresenting the people of Botswana in May 2008. Misrepresenting to the people of Botswana in May 2008 that it had refurbished the badge and it was generating 125 megawatts of power to Ghanaians. This is Samuel Brian Boabeng Awoshi. He sent in that one. I'm just trying to see if I can just get only Balkan Energy matters, because there are all sorts of the other matters that are coming up. This one says, should we really care about what name we give it? Well, like Kweku is saying, we shouldn't care, and Aiko too says we shouldn't care. But some will insist that technically speaking, it's not a judgment debt.
It is a debt.
Why do we
You
want
are
to call
going
it
to
that way?
pay.
Okay, you say it's a debt. It's not a
You are
judgment
going
debt.
to pay. It is
Okay.
a judgment
Arbitral
debt.
award.
Suing from
No, they prefer arbitral.
suing
award.
from a court.
Okay, so judgment debt or court settlement. The most worrying and important thing is that the state will have to cough up the $12 million to Balkan Energy. As to the sovereignty of our courts, I will say that our courts are courts of law, and so will give judgments based on the merits of each case. Our governments should be circumspect in entering into contracts. God save Ghana. This is Salas Samuel Amo from Kenya. Say, most of your messages now that I have here are in respect of the EPA, not on Balkan
So,
Energy. We have moved on a bit.
Can I read that thing? It's for
Yes.
clarity.
Yeah, go ahead.
It says the conceptual.
page is this?
is well, mine is not paged.
Okay, go ahead.
Yeah, I'm talking of the Supreme Court
Right,
one.
right.
Says the conceptual discussion thus far as to what international business or economic transactions come within the ambit of Article 1815 has been without prejudice to a determination on the actual facts of the present case of whether or not the PPA in issue here was required to be submitted to Parliament. Our next task, therefore, is to examine some of the specifications of the PPA in order to decide whether it is an international business or economic agreement to which government is a party within the meaning of Article 1815. Now, this is it. Our general impression upon reading the submissions of the parties is that the overall transaction involved here was a foreign investment by a U.S. investor in a power generation project to supply power to Ghana government, and that the government was a party to this transaction. We are viewing the transaction in the run without resorting technically to the piercing of the corporate veil doctrine. We interpret transaction in this context as meaning a series of agreements or acts united by the purpose of attaining the project objective of the parties to it. We will now set out the circumstances which support this impression and whether a transaction of this nature comes within the ambit of Article 1815. The last paragraph says, the PPA between the government and the first defendant was a result of negotiations between a foreign investor as the third defendant acting on behalf of the owner of the second defendant and the government. This is a significant foreign element in the transaction. Secondly, the first defendant, though a Ghanaian company, is wholly owned by a foreign entity incorporated in the United Kingdom. Thirdly, the managing director of the first defendant is a foreigner. The third defendant and control of the management of the first defendant is in foreign hands. Fourthly, the PPA contains a clause providing for international commercial arbitration. Lastly, there were other clauses in the PPA which are usually associated with foreign investment transactions, such as the waiver of sovereign immunity clause and the following clause set out in the plaintiff's statement of claim. So that's the kind of argument I was trying to make.
Thank you.
That is all.
Thank you very much. Some of your text messages here. Pak Ganiwu in Savlugu says something. The problem is not about the judgment debt. The problem has to do with our leaders entering into contracts with private people without any recourse to Parliament. Let's unanimously blame the NPP government for engaging Balkan in isolation with the legislature, which represents the people. This one says, now if we don't take care, our president will sign the EPA agreement without taking our views, and I wonder why we keep on saying democracy is the best system. Democracy is more than dictatorship. Okay, the investor could not be punished for the failure of Ghana government to seek prior approval of the foreign agreement from its parliament. For that reason, the international arbitration was right to consider what was due to the foreign investor. It is consistent with international rules of engagement. Kofi Atta in Cambridge, United Kingdom, sent in that one. Kofi Sika says, so when do we say there is a contract or not? Is it when Parliament has approved or when an MOU is signed? Didn't the same thing happen in the Wyoming case? Was there any work done in the Wyoming case? Again, doesn't this tell us that a ruling by our Supreme Court in a case involving multinationals is not final, especially with the Isophoton, Waterville, and Waterview? Now, the ugly noises of go and get the money could cease. Okay, so...
No, but the Wyoming thing doesn't come in here at all. I suspect maybe he's talking of Waterville. Okay, Wyoming had no contract with the state.
Yeah, but he's talking to the tenor of the matter in respect of lack of parliamentary approval being used to invalidate all of those agreements.
Yeah, but the Waterville
and
thing...
he is saying, to the extent that we have similar other, contracts that have been invalidated by the Supreme Court, these other people are likely to go to the international arbitration.
The Waterville contract, the government of the day knew it had no parliamentary approval, and in cancelling it or telling Waterville that it had not come into effect, they referred to the fact that condition precedent, which was parliamentary approval, had not been achieved. So the contract died.
I see. Thank you. This one from Eugene in London, he says that, in my opinion, Ghana should not sign what looks like an attractive deal. Individual African countries should negotiate and do business with the EU, based on this EPA. Over time, say 5 years or more, ECOWAS bloc can, with individual countries' experience, go on and sign it. Thank you, Eugene, sent in that one. Most of the messages that I have now here have to do with the earlier matters that were discussed and not the very present one. Now, we have just about 6-7 minutes to go, and I want you briefly to tell me, part of the question I asked you was, why is it taking Parliament so long or forever to make sure that we have a law that regulates Article 1815? Because that is the biggest problem.
First of all, to understand 181 is to make sure that Parliament, on behalf of the people of Ghana, performs the gatekeeper role in a state relating with an entity outside the country in ways that will commit the state's resources, money. And if it does so, it's important that in that relationship we benefit more, that it cannot be the prerogative of any individual, including the government, to go into such agreements without recourse to the people and without having the people in mind that we are going to benefit more in that relationship. So Parliament is allowed to examine and give approval. And that is the spirit of 1815. But it creates problems sometimes, because in situations where the government, the executive will enter into a relationship without recourse to Parliament, that relationship can be said to be valid in the eyes of the person who are coming into the relationship with us. But in the strict interpretation of the law, it will be declared null and void, because it's not one of the conditions, a key condition precedent, being Parliament, would have been overlooked.
And that's why some have said that that is a danger to our relationship with entities like Balkan, so to speak, because you can perpetrate a fraud on them. Now you hire them to do something for you, they come in to do it, and then you turn back to say, look, I didn't get approval, so get off. Or if I give you money,
now the question is, should we amend the law, or should we popularize the law so that others will understand it? Or should we amend it in ways that can still accommodate such inadequacies? That when a transaction gets to the point where a contract is signed and a good is provided, you can no longer renege on it and say that it hasn't gone through the courts, through Parliament. I would say that the second option, or rather the first option, is what I go with. That we don't need to amend the law, we need to popularize it. And the Supreme Court need to interpret it and give it clarity, not Parliament. The reason is that international transactions by their nature have a huge implications on the national purse at every one point in time when it's about money. And so the Parliament has to have a look at it. My concern is the bite Parliament has.
You say you don't need a law, but when you read the whole of Article 181 in perspective, for example, when you read 181.3 or is it 4, 181.3, which says that 181.4, which says that an act of Parliament enacted in accordance with Clause 3 of this article shall provide, and it's giving you a guide and telling you that you should be enacting an act to make sure that
it
this
is not Parliament that will be enacting the act. Let me explain.
But that's what the law tells you.
But let me explain something. It is Parliament that should do it. But it is not Parliament that should initiate it. Normally, Parliament, unless it's a private member's bill, and it's not even going to be initiated in Parliament, the arrangement in the methods of our law, making laws, is that it originates from somewhere. It originates normally from the executive.
Majority of governments are...
and then it comes to Parliament.
The president's appointees are in the Parliament.
Yes, and that is where the danger is. That if you don't amend it, the value of it is still lost.
Thank you.
You
your point
remember
is well made.
the presidential jet saga 2000. This matter came up in Parliament, and it's very interesting. All sides discussed it, and they almost had a consensus that 1815, something should be done about it. You listen to what Babin said here. Mr. Speaker, now the executive in tying itself to apply it, that's 1855, did exactly what they have done, which is now before us. Now, if this House is of the view that procedure is not in tune...
Sorry, we have this distraction. Whose phone is it?
It's my alarm.
Sorry, your alarm. Sorry about that.
Sorry too. He says, I'm sorry. Apologies. Mr. Speaker, now the executive, in trying itself to apply, it did exactly what we have done, which is now before us. Now, if this House is of the view that the procedure is not in tune with the provisions of Article 1815, it is now on this House to itemize and come out with the right procedure that the executive should follow. Because, Mr. Speaker, the procedure in Article 1812 is not the same as the procedure in Article 1814 or 3. They are different. In trying to marry these two differences in Article 1815, you are likely to come out with a scenario that will definitely be different from Article 1811 and Article 1813. That is the crux of the issue. The fact that Parliament has not come out with these modifications is the cause of the problem.
All right.
This is 2016 February.
Abi.
The House.
Abi, shouldn't we have some sort of pressure to get them to do this immediately?
Oh, why? That is...
Because the problems are coming up and the little pairs, is suffering.
You should say, to do what? You see, to do
the
what?
Constitution says do the
specific guidelines.
Let me come in here.
Yeah.
I think rather what we are missing is 1815.
Yes, that's one.
It says this article shall, with the necessary modifications by Parliament,
That's right.
apply to an international business or economic transaction to which the government is a party as it applies to a loan.
Yes.
So, as for loans, we know what we ought to do.
Yeah.
But when it comes to international business or economic transaction, that is what they are calling on Parliament to look at.
And so
The
it's Parliament.
necessary modifications.
Modification.
That
The
is what they
Constitution
are
says
calling on
that.
Parliament to look at.
Right.
20-something
It's
years
not the fact
gone.
that you're going to take a loan.
Yeah,
We
that's-
even have a loans
these
act.
matters are
We
coming
have a loans
one
act.
too many, and I think
It's
that
been on the table for too long.
It's been
In
a
Asia.
long time coming. Parliament has done something in regarding the issue of corruption. The Speaker has indicated that they should come out with guidelines quickly. I think this is one of the areas too that Parliament must consider seriously and come out with guidelines.
For how
because
long?
These are becoming too many for the nation. It's becoming a very, very expensive.
Like
for the
we're
nation.
saying, the debate has been had, and even on
Yes,
the floor,
even on the floor.
almost to the point of consensus.
That's right.
When are we waiting to get this done?
Let me also add quickly that if you allow an Attorney General some independence, avoid this political, interference for purposes of political, expediency.
We might get
Then
it
we
right.
may get it right.
All right.
Because if government decides that we are doing the business, and therefore whatever Attorney General is telling us, we know if he's going to listen to that,
All right.
then we'll continue falling
But
into
I'm
this
told
kind of
apparently
Okay,
there's a committee.
okay.
Some people may know there's a committee that has been set up by Parliament
Yes.
to look into this matter.
Okay.
It's a fact.
Yes.
Okay. Okay. Then they should be, rolling up their sleeves and doing this faster. You have been listening and watching Newsfile. This is your most authoritative news analysis show. I'm Samson Ladiayeni. My guests have been Abdul Malik Wekubaka Jr., Editor-in-Chief of the New Crusading Guide newspaper. Abraham Amaleba is a lawyer and also a lecturer. The Honorable Abdul Rashid Hassan Pelpo is the Minister of State at the Presidency for Private Sector Development and Public-Private Partnerships, MP for Wa Central. Honorable Ayiko Otu is former Attorney General and Minister of Justice. Thank you very much indeed for your comments and all your contributions. The Joy News